A lot of employers are unaware of the requirements, certainly in New York State, that you keep records of the hours that your employees work and of their pay rates. So oftentimes companies will hire, for example, outside payroll companies to handle these matters, and certainly that's advisable, and they can keep track of all of the hours the employee works, as well as the rates of pay, any raises, any overtime that's paid, vacation, etc. But sometimes employers don't want to go that expense, and they keep that information themselves. Oftentimes employees are required to punch clocks, or there might be a sign-in or sign-out sheet, or maybe there's just at the end of the week some type of a simple sign-off on a payroll record. But the one thing that a lot of employers don't do is they don't keep track. They trust their employees. They trust, especially in smaller companies and smaller employment situations, they trust that the employees are getting the job done within whatever number of hours that takes them to get it done. And they trust that the employee is taking the appropriate lunch break, and that the employee is not extending their time beyond 40 hours a week, where it might trigger an overtime issue. However, you can't always just trust the circumstances, because when you do that, you find yourself oftentimes in a situation where you're being the subject of a lawsuit from an employee, for example, who could have left the company many years earlier and now feels that they're entitled to receive additional pay for all of the work that they put in. So it's really critical as an employer that you keep track of your hours, you keep track of your employees' rates of pay, whatever overtime it is that they're entitled to and that you're paying them. Their lunch breaks and all of those things really need to be accurately recorded. This way, if you end up finding yourself on the end of a lawsuit, your attorney can at least have the documentation to support your defense and support any argument that you can make to try to, in a way, distinguish the claim, whether the claim is 1-year-old, 2-year-old, 3-year-old. These things can really take on a life of their own, and you don't want to be subjected to that down the road.